Hello, 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 everybody. Okay, so I'm sure people will jump in here soon, as soon as they see that we are live. And today we are covering the Lori Vallow Daybell hearing that is going on right now. So I let it get a little bit ahead, so please be patient if you're just joining. We're going to get through this. So if you have already heard or whatever, please don't mention it. Let me get through this and we are going to hear what's going on. Now, Lori Vallow has asked the court to throw out her guilty verdict and set a new trial. So we're going to hear why that is, what the defense has said. I've already gone through some of this. We are waiting right now for the judge. The judge is going to make a decision on this shortly. So let me get through everything that is going on in the courtroom right now. Hello, everybody coming in. Sandra, Tracy, Nana, good morning. Crass and Crime, Justice, Sandra, Comptu, Bonnie Baker. So please, if you have information from other sources, please keep it to yourself. Don't share that here. Okay, so the hearing was scheduled to start at 9:30 a.m. at the Fremont County Courthouse. They're not in Ada County. They are at the Fremont County Courthouse, and Judge Boyce is hearing this motion. So Prosecutor Rob Wood is there. Lindsay Blake is there. Lori walked in wearing orange and white striped jail clothes. Her lawyers walked in with her. She also has ankle shackles on, and she's smiling and talking to John Thomas, which is one of her lawyers. Lori was also wearing orange Crocs and socks, the usual Madison County jail wear. Also, Lori had her hair all curled up, and it looks like she has makeup on, the usual, right? And none of the family was present from what is being said. There was many reporters in the courtroom. The detectives are also there. Everybody wants to hear what is going to happen in this case. Judge Boyce entered the courtroom and stated they were officially on the record for a motion for a new trial, which was filed on May 25th. Let me just bring my microphone closer here. So Jim Archibald, one of Lori's attorneys, began the arguments, was saying our client still reserves all of her other appellate rights other than what's contained in this motion for a new trial. Now, there are some things that he says that are like, what? Are you kidding me? Archibald stated that he anticipates that if the court grants this motion, the state would seek to combine Lori and Chad's cases again. Archibald said, which is weird because they really pushed for this speedy trial, which meant that because Chad Daybell was saying he kept pushing his out further and further and further. Lori's defense attorneys could have said, okay, look, we're going to waive our speedy trial so we can have these trials together. Now he's kind of backtracking on, how they handled this. Okay. Good morning, everybody. Archibald states that he anticipates that if the court grants his motion, the state would seek to combine Lori and Chad's cases again. Archibald says, I don't fault the court as much as I do the government for the way that this indictment was filed. Archibald was arguing that the language in the indictment is not correct. Therefore, Lori should be granted a new trial. The indictment says the conspiracy was among 5 people, Lori, Chad, Alex, and other co-conspirators. Archibald said, for the court and the government to then, at the end of our 7 weeks in Boise, to all of a sudden say, just kidding, not really 5 people, it's 2 or more because of the definition of conspiracy. This was a mistake created by the government. So he's giving his reasons why she should have a new trial. For context, according to Cornell University, the legal definition of a conspiracy is an agreement between 2 or more people to commit an illegal act along with the intent to achieve the agreement's goal. Archibald says, I think the court misled the jury. It led to the amended indictment. Archibald saying the clerical error that led to the amended indictment was not actually a clerical error. We believe that this mistake from the way the government drafted their indictment was prejudicial and should not have been allowed. Archibald says the government is referring to the prosecution. Archibald says our third point for asking for a new trial is based upon a news interview that a juror gave to a reporter. Now, we all know that interview was Nate Eaton did an interview with one of the jurors, and he says if there was a face of evil, it was hers. Both the juror and the reporter were very respectful of the process, the attorneys and all of court staff. The juror and reporter indicated their respect towards the process from the start to the finish of the trial. I'm not criticizing either of them, but Archibald was arguing that the juror was interviewed by Nate, and he said he was confused by the jury's instructions before the deliberations began. Based upon our motion for a new trial, if the court grants the motion, then we'll again attack a 404B evidence. Some courts just say a mile away from this character evidence because of the trap. Some courts just stay out a mile away from this character evidence because of the traps that it sets. Archibald says if the motion is denied, these motions will be taken up on an appeal. Archibald said, we never asked. Okay, here's where it gets good, you guys. They didn't ask for a separate trial. He is correct with this statement he is about to say. But what he did do was continuously demand a speedy trial, which he knew was going to cause somewhere down the line the judge having to separate her trial from Chad's. It was inevitable because every time a new trial date was set, Chad's attorneys then put that date off. So they seen what was being played there. Please smash that like button on your way in, guys. Let people know that we are live covering this. It's a great help and it's free to do. So thank you. For those of you who have smashed the like, please go on out. If you haven't smashed that like, come on back in. When you come back in, make sure you got live chat selected at the top of your screen so you don't miss anything. Also, I'm going to ask some mods, if you do see anything being shared from other sources, please delete the comment and give a warning. So what Archibald says, he says, we never asked for a separation of the trials. It was Chad Daybell who asked for his own trial. That's why we're okay to have our new trial reset at the same time as Chad Daybell's trial. So now they don't have a problem with it. Now that she was convicted, now they want to have their new trial, if granted, coincide with Chad Daybell's. So in that trial, they're both retried again. She's retried again, and he's tried for the first time together. And hopefully they can shift all the blame to just Chad because they failed at proving her innocence in her own trial. I'm on to you, Archibald. Lindsay Blake now is going to begin the argument for the prosecution. They're talking a lot about legal talk about the Idaho Criminal Code. To clarify, the first reason Lori's attorneys want a new trial is because of a modification to the jury instructions during the trial to include the term and/or rather than the and that was originally there, dealing with the charges of conspiracy. You're very welcome, you guys. Thank you for being here. Please smash that like on the way in. Lori is very diligently writing notes on a legal yellow pad. Lindsay Blake says, the next one we look at is whether or not the jury was misdirected in a matter of law. Someone is weed whacking apparently outside the courtroom, so it's really hard for a lot of people to hear what's being said. Lindsay Blake is arguing that the amended language in the indictment doesn't matter because, if anything, it only helps the state's argument. Blake is referencing other court cases where amended indictments have ended up not impacting the outcome of the case. Blake says the defendant was always on notice that she was charged with grand theft. Again, on that ground, the state would argue that the defense fails to meet any burden. Blake said any statement reported to be made by juror number 8 should not be considered by this court. If the court were to consider those arguments, the defendant's motion would still fail. Lindsay is quoting the juror who said that the jury instructions were clear while they were deliberating. A follow-up interview was done where he was asked if he found the jury instructions to be confusing, to which he said, "I personally did not." Juror 8 is unequivocal in stating the jury instructions were clear and that 404B evidence, which was introduced, was not considered for any purpose other than the instructions provided by the court. Blake said in the follow-up interview, the juror specified he did not observe anything of that nature until after he had been released from jury duty. This is in reference to the body camera footage that he said he's seen of Charles Vallow. Mouth wants to say value. Charles Vallow speaking to police about Lori, and we all seen that footage where he's begging the police to please hold her, have her assessed and everything, that she's saying he's become a zombie, all that. So that's what she's referring to. Blake says, for all those reasons, it is our position that the defense has not met any burden and there are no grounds for a new trial. James Archibald is now having a brief rebuttal. He says, Jim Archibald says, the court read the indictment to my client when this case started. The indictment language is the conspiracy of these 5 people. My client was put on notice that a conspiracy is 5 people. My client was not read the jury instructions when she was arraigned. Archibald says not until 7 weeks later was the jury and my client told that, just kidding, conspiracy is really 2 or more people. Well, the law states 2 or more people. So anyway, Archibald says, are the defense lawyers supposed to tell our clients, hey, just ignore what the judge just read to you, just ignore what the grand jury indicted you on? And with that, he's done his follow-up argument. Boyce is prepared to make a ruling on the motion, and we are going to hear that. They took a small break. Lori smiles again and speaks to her attorneys as she leaves the courtroom. Now, they took that little break. Lori is re-entering the courtroom again. She just ran into the wall and almost tripped due to her ankle shackles. Karma. I wish she would have ran into the wall. Oh, she did run into the wall and almost tripped due to her ankle shackles. Oh, now she's going to claim a lawsuit for falling into the wall. You watch. I can see it coming. The first motion rationale is the argument. This is Judge Boyce talking now. He's going to give his order on the matter. Judge Boyce says the first motion rationale is the argument that the court misdirected the jury as a matter of laws as it related to conspiracy. Boyce is going over the rulings in similar cases that Lindsay Blake discussed. Boyce says, as it relates to a conspiracy charge, if there was a variance between the and or, the court does not find in this case that it has been shown that it would violate due process. Boyce says, the question is whether or not the defendant had notice about the charge of conspiracy. The overt acts did not change. There wasn't an amendment to the indictment that allowed for any overt acts. Boyce says, I don't find that there is being a showing that if there was a variance here, that it was a fatal variance. Judge Boyce says the court does determine that the first grounds for a new trial, the allegation that the jury was impermissibly instructed on conspiracy, he's denying that motion on that ground. Boyce, hang on a sec. Okay, so he denied it on that ground. Boyce says the amendment to the grand theft charge was a permissible amendment. Boyce denies the argument for a new trial based on the indictment changing the number of conspirators from 5 to 2. Boyce said the third argument is that the juror interview revealed that the jurors were not properly instructed. Judge Boyce says the juror interview was never submitted to the court in an affidavit, so he is not seeing it as evidence. And we are all caught up, so as the rest of it comes out, you guys, I will share it with you. And that's where we're at right now. He is still in the middle of making his decision. We are now caught up to everything that happened earlier. We are now back after the break. And we're at the part where he's talking about the third argument, is that the juror interview revealed that the jurors were not properly instructed. So since the defense did not submit that to the court in an affidavit, he cannot, use that in his ruling because it's not in evidence. Hello, Bubsby. Hello, Vicky, Heidi, Lori, Fruitfly, Be Kind, Caroline, Bonnie Baker, Sandra Stevens, Justice Merrick, Crafts and Crime, Tracy, Sandra Stevens. Hello, everybody coming in. Leslie, good morning. Okay, so Boyce says that the courts don't usually go in and ask the jury why they came up with the outcome that they deliberated about. Boyce says since the interview was never submitted as an affidavit to him, he doesn't have any of the jurors' quotes or the interview at all in front of him. So I see this all being denied, you guys. Boyce says during the course of the trial, the jurors each day signed a daily affirmation and declaration that they had not received any improper prejudicial information because they were instructed that they were prohibited from looking up anything about the case. Judge Boyce says, I don't have any evidence that the jury drew straws or flipped a coin. Boyce said there was never any contact made to the court by any juror about any outside influence. Hey, Tiki Sass. Kate Bell, Proud Southern Girl. Vicky H. Judge Boyce says, again, the juror interview was never submitted to the court in an affidavit, so it is not in evidence. He cannot rule on something that is not in evidence. Well, that was pretty dumb of them not to submit that. So like I said, you guys, by the sounds of this so far, he's not going to grant the new trial. So what they're going to do is they will appeal it to the appellate courts, and they're going to probably also include this in their appeal. There's so much going on today, you guys. If you guys haven't checked out my community tab on my YouTube page, I've got a lot in there. So also, while we're waiting for more information to come out on his ruling here in the Gabby Petito case, her parents have won more battles on motions that the defense, which is the Laundries, have filed. They do have to give up, and it is all going to be released to the Petitos, to Gabby Petito's parents. All the text messages from August and September. So from the time Brian left Florida to go back to where they were out west, and then, you know, Gabby's death happened, and then he traveled back to Florida. All those texts between him and his parents are going to be released to the Petito family. So that's a big win for them. Also, the Laundries filed a motion to have the case dismissed. That was denied also. So two big wins for the Petitos, for Gabby Petito's parents. Two big wins there. Let me just see if anything else is out. Okay. Judge Boyce has brought down his ruling. There will not be a new trial for Lori Vallow Daybell. End of story. So no new trial for Lori. So she will not be reuniting with Chad and having a whole new trial with Chad. Judge Boyce has denied the motion for a new trial. So she is going back to the slammer, where she will undoubtedly file an appeal with the appellate courts. Judge Boyce had also added that the court finds that the exceptions don't apply here, and I also find that the court can't consider these statements as they fall outside of the exceptions. So she has been denied a new trial. The verdict stands, and she is going back to the slammer. I bet she is angry. I bet. Let me just see if they're going to give us some kind of reaction if they see. Judge Boyce says, I don't find any sufficient evidence for a new trial to be admitted. So that's the end of it. The judge has left. Lori is again smiling at reporters as she leaves the courtroom. So I don't know what she thinks she gained by that, other than getting out of jail and being under the spotlight again. But I didn't expect her to get a new trial. So that being said, for those of you who haven't seen, we did a new live yesterday or the day before on Suzanne Morphew. We go through all the new filings regarding Barry, what he's up to, and then we ask the cards to answer some questions regarding the Suzanne Morphew case and what is coming. So if you haven't checked that out, go underneath my live tab and you will see that. That is also there from yesterday. Yeah, bye-bye crazy Lori. She is done like a donut. Now, I haven't heard nothing about Letitia Stout, whether she is filing an appeal. We heard briefly that her lawyer stated that they were going to file an appeal, but I haven't heard any information regarding whether that is happening. Now, also today, the Delphi murder case. Richard Allen is also in court today. I haven't heard nothing on that. If I do, I will let you guys know in my community tab what happened there. Let me see what else. Oh, the Brian Koberger case. There's some stuff going on with the Brian Koberger case too. I believe that he is back in court on June. Let me just see. Okay, Barry's in court. Barry Morphew's in court June 26th. Let me just go back here and check. Let me just see here, you guys. Yeah, the Brian Koberger case, the defense has filed a motion to stay the proceedings. Now, what that means, if you guys are following along in that case too, he wants a stay put on the case because the defense is contending that it should be stayed because of the grand jury indictment. They still haven't got everything that they want from that. And they say that they want to be able to go over the grand jury indictment before they proceed on anything, because I feel that that's why he stood silent. He's not entering a plea because he didn't agree with the indictment, and I think they are going to contest it. So until they get what they want from that grand jury indictment, all the paperwork and everything, they want the case to be stayed, which means nothing further happens in the case. Just like, do you remember when the case against Lori Vallow was stayed because of her incompetency and she was being evaluated? Well, they're asking for the same thing in this case, but for the reason that they want the grand jury record before they proceed any further with anything in this case. So Lori Vallow has been denied a new trial. This is good. This is good. The judge also made the Brian Koberger case. The judge also made a ruling on that. The gag order stands. We know that that was in court a couple days ago, and the lawyer for Kaylee Goncalves family was fighting to have himself and Kaylee's family not included in that gag order. The judge denied it, so the gag order stands. Nothing yet. I haven't heard anything else yet regarding the motion that all the media made for cameras in the courtroom. I haven't heard the outcome of that motion yet. So I believe that one is still being thought over by the judge. And he also, at the end of that hearing, he took it under advisement and he said that he would make a written ruling on that also. Now, we don't have no ruling on that as far as I know yet. I will be checking in and watching for that today. Also, a lot of people were asking in the comments about the Unabomber, Ted Kaczynski, or whatever his last name is, who was found deceased in his jail cell. That was suicide. He did commit suicide. So let me just see if there's anything else here. So there was a hearing regarding, if you guys have been following the Barry Morphew case, there was a hearing regarding Linda Stanley and if she should be penalized or sanctions against her or whatever. But the Colorado Attorney General, I think, or P. Weiser's office agrees that discovery violations were egregious enough to penalize DA Stanley in her discovery violations, yet two other judges say the sanctions were appropriate. So, and if you remember that case with Barry Morphew, the judge took away almost every one of their expert witnesses. So they had no case. The judge took their case away from them. So I don't know what's going to happen with that, but let me just see if there's anything else new here that I can fill you guys in on. Now, as far as Chad Daybell, I did put it in the comment, the community tab. His trial is set to begin. I got to go all the way to next year, you guys. His trial is set to begin April 1st of 2024. And I believe that there is a pre-trial in February. Let me just get there. That's May. Pre-trial is February 22nd, and his trial is to start April 1st. So let's see if that actually happens, you guys. Let's see if I've got anything else. I'm just going through some of the information here, you guys, that I've been sent. There's two things here that I want to share with you, but I want to verify it first. I know, just as I end this live, I'm going to... I see something else that I wanted to share. I think I covered everything that I verified so far. Like I said, there's a bunch of stuff that was sent to me, but you know me, I don't talk about it unless I can verify it myself. So Brian Kohlberger has another hearing, you guys, set for June 27th, too. So he has various on the 26th and Brian Kohlberger on the 27th at 1:30. And that motion is to, for the defense to give notice of the intent to present oral argument and or testimony in support of the motion. The motion is to, that's the one for staying the proceedings. So I do believe that that is all I have for now that I have been able to verify. I believe, yeah, these ones here I have to verify first. Okay, so that is what we have for today on Lori Vallow. A little bit of updates on other cases too. So we'll wrap this up. You guys can get back to doing what you need to do. I have a bunch of emails that my daughter sent over that I have to go over and look at. And check those out, see what's going on there. So, oh, thank you, TK Sass. Okay, so with that being said, you guys, I'm going to wrap this up. And as I usually do, I am going to mention, please stay safe, Always make sure of your surroundings. And until the next time, you guys, I love you guys to the moon and back. Take care. Bye-bye.